This conference will now be recorded.
Hi everybody, welcome to this session. Hopefully you'll get quite a lot on the aspects of how to protect your assets going forward. I'd like to, just go back a little bit, introduce you to the Protector Trust. It's an asset protection strategy that was developed by a firm of solicitors called Abbott Morley, who specialise in asset protection, estate planning, and we've been now working with them for a period of about 9 to 10 months. They developed this unbelievable concept on how to protect assets, a bit like a castle and the royal family, in a sense, where you've got one leading member being the Queen, and then she controls all the assets for her lineage or bloodline, relatives going forward. I guess the benefit, the beauty of this particular structure, the Asset Protection Trust, is that it can take care of all of your assets, whether it be a business, if this castle represents all of your assets, the business might be this section here, your family home might be here, an investment property might be here, your super fund may be here, but all of the net equity can be protected in a very efficient manner in producing some very creative and very important documents that I guess stops people from attacking your assets going forward. So the castle is basically, all of your assets, if you think about it that way, and the moat, which is probably the most important thing, is what you do right now to protect your castle against future attacks from creditors, from liquidators, from family members, from ex-wives, and so forth. The moat, the bigger the moat, the more protection can be created for your assets. As I said, the protector gives you the armor to shield your assets from attack, and I guess it's depending on how much armor you put on is reflective of how much protection you're going to create going forward. I guess before we get started, let's talk about the common parties when we're dealing with the Protector Trust. There are some common people and some common entities that need to be incorporated in the future documentation, and the common parties tend to be, that I've seen, individuals, trusts, companies, and self-managed super funds. I guess with a trust, it can be an asset protection trust, is where all your assets are, I guess, accumulated, and a company is your trading business. You could also have a trading trust as well, but we do not recommend that you park your assets in a trading trust, because what we're trying to do in this particular strategy is separate the assets from any risk that may be associated with the particular structure that you've got. So the common parties, they're the typical common parties. Individuals can be husband and wives, it can be individual directors or shareholders. The trust can be the beneficiaries, company can be the shareholders, and the SMSF can be super fund members. So they're the common parties. I guess the whole concept of the Protector Trust, which makes this strategy absolutely something that you should put on the table, is that you're not moving the titles of those assets across to the protection trust. Like in the old days, solicitors used to protect assets for clients or for people by shifting assets from their individual name, their trust, or their company to another trust where it was shielded from attack. In this particular situation, what we've got is that we're not moving the title. As you can see here, it says that we're going to move equity. We're going to gift equity basically from an individual or a trust or a company or a business across into a protected trust to protect it against future attack. And we're going to shield it with documents that give you first right of to those assets, or your bloodline first right to those assets if something happens to you or your partner and so forth. So we bring into the equation this concept called the leading member. In other words, you know, we make a person a leading member of the protected trust, and if that person gets attacked, he or she, what happens in the constitution and the deed of this structure, it allows for that person to step down, and a new trustee and a new director of the company and is created, because you do not want that person in the, I guess, future litigation processes or court battles that may go on. So basically, by stepping out, we're protecting the assets that belong, I guess, to the family, you know, and it's controlled by another leading member that you can nominate, that you can trust, and you can have operate the particular trust going forward until obviously everything is resolved. So we're basically moving equity, okay, across into the protected trust. So the benefit of doing this is, in the old days, because solicitors were moving physical titles, there were costs, significant costs in doing that. So for example, if you had an investment property sitting in your individual name, and you've had that for 10 years, and you bought it for, I don't know, 400,000, and today it's worth $1 million, then by transferring the title across to a trust to protect it, basically in the old days, which is a great strategy still, but it's very expensive. See, the problem is, as soon as you transfer the asset, there's been a deemed disposal, and there all of a sudden what you have got is a capital gains tax issue. So you bought it for, say, 400, you basically, you know, it's worth $1 million. So you've got a $600,000 capital gains tax issue that you've got to deal with. That's number one. Second thing too is, when there's a transfer of title, you know, again, the other cost, which is significant, is stamp duty. So what this particular model does, or the protected trust from Abbott Morley has provided, is this ability to transfer that asset by gifting the asset instead of transferring the title across to the trust. So that is a major benefit. And as soon as the trust receives that gift, what it does, it then goes and puts together a loan back to that individual. In other words, you loan back the asset, and then we have some sort of arrangement, legal arrangement, in terms of a lending arrangement, is probably a better word, from the protected trust to the individual or individual couples, or the trust or the company, depending on which asset is transferred across. So we've got a gift to the trust, and now we've got a loan back to the individual to, you know, to utilize that asset continually going forward. So basically, you've got a two-way street. So you've got the individual and the protected trust working together, where the individual still holds the title and now has a loan. However, the protected trust owns all the equity now. So this is an amazing structure, because you've still got control of all your assets. I'm not sure if everyone's heard of the saying is that you own nothing but control everything. This is sort of you know, an extension of that. So you basically you have all the assets in your total, I guess, castle. You control it, but basically you don't physically own any net equity in this arrangement. So let's continue on. I want to give you an example of how it can work. I'm going to use the family home. That seems to be one of the assets most people want to protect going forward. There's a couple of other ways which we can deal with this, but how to explain it within the Protector Trust this is a good example. So let's use an example here where there's a family home valued at $1.8 million. There's a loan of about $800,000 on it, and therefore the equation is very simple. There's a net equity of just on $1 million there. So what happens in this Protector Trust strategy? We design that the individual who owns that particular property or couple gifts that net equity, the $1 million, not the 1.8, the $1 million, which is the net equity, which is basically after taking into consideration the bank's first mortgage on that particular asset. So we gift the equity to the Protector Trust, and then what we do is we enter into a loan back and provide the loan for $1 million back to the individual. And I guess what I want you to think about now as we're sort of illustrating this particular, the transactions that need to happen as a result, as you can see, there's got to be a gift. Also, number one, there's got to be a trust that needs to be created or we can utilize within your current structure. There's got to be an asset that you want to, that has net equity, that's got to be gifted. So we've got to design create a gift deed, and then we need to loan it back. So we've got to create the loan agreements, and we have some very special mechanisms on how we do that without involving physical cash at the end of the day. So what are the documents required to create the full armor for the Protector Trust? As you can see there, I've listed on the right of the screen, you need a leading member trust deed. In other words, it's got to be driven by a leading member of the family, and you can have substitute leading members if that leading member has to be eliminated out of the structure because of, let's say, bankruptcy or some sort of litigation. But also if the member dies, if the member gets, has a health problem such as dementia or something like that, where they can't think for themselves. So another leading member, which is a family bloodline member, can step in and take control of the trust. And the same with the leading member trustee company, that also the directors and the shareholder needs to be a leading member of the family. And again, the provisions in the constitution are the same as with the trust deed. And that is, if something happens or we need to do something to remove the original member, we can do so, and the constitution and the deed allows us to do that. Also, we need a solvency certificate. Why? Because at the end of the day, we're loaning back a certain amount of money back to the individuals, and those individuals need to be solvent in order to take on that particular loan back. And I guess that's no different to any other banks. That's exactly what they would do. They would do a serviceability to make sure that the transaction has legs. We also need a deed of gift. That's another document that needs to be created. And Abbott Morley, our solicitors, again, prepare all these particular documents. The deed of gift is the physical gift of the net equity across to the Protector Trust. We also need a promissory note. That is an IOU. This is where we don't use real money. We use a promise. Like back in the old days, promissory notes used to be very common, where people say, look, I'm going to lend you money, but I'm going to promise to pay, you're going to promise to pay that back to us over a period of time. So when you have a promissory note, it's basically a loan that is created. We also need a loan agreement with all the terms and conditions in there, including the amount of the loan, which is equal to the net equity. The interest rate, we put a nominal interest rate there of 0.01%, and then the term of the loan being 25 years, 30 years, or for the life, or until you, for a date that you're comfortable with. It could even be 40 years or 50 years, depending on how young or old you are. We obviously need a mortgage deed. Why do we need a mortgage deed? Like any other bank, you want to be protected, because what we've done here is we've said, okay, well, you've gifted the net equity across into the protector trust, and at the end of the day, you still own the title. So if someone attacks you, you could say, okay, well, yes, my house is worth $1.8 million, but I owe the bank 800, but I also owe my protector or a protector trust or a trust the other $1 million. So you personally have no equity in this particular property because it's tied up with the first mortgage with the bank and a second mortgage with the protector trust. And that's how you basically shield your asset from any future attack. You can also have personal guarantees if applicable. Haven't seen this done too often, but it is certainly also something that we could add another element to the armour, I guess, to create a much wider moat for the clients that require it. So I guess some common definitions. A solvency certificate, what is it? Well, basically it's a document which provides information about the financial stability of the individual. So the solvency certificate is basically a document that says that the person has got the capacity to take on those borrowings in their own name. And basically the banks do that when they do their serviceability. Well, if we want to make this reasonably tight, we certainly need to review each individual client's serviceability and solvency issue. We don't want to set up a document like the Protector Trust and then find the person doesn't have the ability to deal with that loan and they're insolvent and they could possibly go into bankruptcy before we know it. So a solvency certificate is a stamp of approval in terms of this financial strength of the individual. The next document, or the next document, is the deed of gift, and you know what that means. A gift of deed is a document that is signed by two parties, where there's a party called the giftor that voluntarily and without payment being required from the other party transfers ownership of the property to the other party. It's a gift. So therefore, as it says there, that, you know, it's done without a physical payment. So a deed of gift is probably one of the most important documents that's created, you know, as part of that moat and as part of that armour as well. The next document I want to just quickly touch on is the promissory note. It's a new term, I guess, but it's been around for hundreds of years. The promissory note is a financial instrument that contains a written promise by one party that notes the issuer or the maker to pay another party, the note's payee, a definite sum of money either on demand or a specified future date. So what I mean by that is normally most of the promissory notes are done that it's paid at some future date rather than regular payments. The promissory note typically contains all the terms pertaining to the debt, such as the principal amount, the interest rate, the maturity date and place of insurance. In other words, if the property is insured, it obviously needs to be noted, and obviously at the end of the day, it needs to be executed with signatures and witnesses as well. So What I think the Protector Trust summarises is, as I said, it is a mechanism to protect your assets, and that means all assets. It's not restricted just to your family home. It's not restricted to your investment properties. It's not restricted to your share portfolio. It's not restricted to your plant and equipment. It's also for those clients who run businesses. We can also protect the equity that you have in that particular business. And one of the other things it also does too is, for example, a lot of clients have lent money to their trading business, you know, to set it up and for ongoing cash flow and so forth. And I've seen lots of companies or trading businesses, doesn't have to be a company, it could be a trust, that they've got loans that are owed to the members in their hundreds and hundreds of thousands of dollars, in some cases up to millions of dollars over the years. So it protects that money, because at the moment most balance sheets that I see, those loans that people have lent to their businesses are unsecured. So if the business gets attacked, their structure gets attacked, they become unsecured creditors. What we want to do is secure that. What we want to do is protect that. So if the assets of the business are sold, then the bank gets their share because they hold a first mortgage, but then you're second in line after obviously some other preferred creditors, such as the you know, other secured loans, or perhaps the ATO employee entitlements potentially as well. But most of the times, any creditor that has got security, like yourself, that you may have created a mortgage interest in that particular business, then you come second in line to the first mortgagee. So it reduces your risk. It allows you to control your assets, which is really important, and it allows you to keep, hopefully, the assets in line, so your family, your lineage, your bloodline is protected in terms of the assets that need to pass to them. I think at the end of the day, it also provides peace of mind that all your hard-earned assets are going to stay within the family group. What I want to do is now just go through a case study that I prepared a little bit earlier, a little bit like the chefs and the cooks. I've done this a little bit earlier, only because the process to create the documents through our legal team takes a little while. So having them already prepared gives us a bit of an edge. So let me just call that up and we can have a look at that. We use, as I said, the firm Abbott and Morley. They have a system that helps us as advisors called Lightyear Docs, that helps us formulate the documentations that required for the Protector Trust, and lots of other documents online. So let me just call up the document and we'll go through that. And I've created one here in the Protector Trust documents called this John Smith Protecting the Family Home as an example. I'm just going to call up the document that was already prepared, and we'll go through that together. In this particular case, we've created the Protector structure, and in this structure, there's the contents of all the documents that are included the Family Protection Trust. So we've created a new trust here. We've assumed that there's already a corporate trustee that's been upgraded to allow for a leading member. So we've created a Family Protection Trust in this example. For most clients don't have a Family Protection Trust in place, or any other trust that is going to be appropriate. We're going to create the solvency certificate, the deed of gift, the promissory note, the loan agreement, and the mortgage deed. So as you can see, there's about 71 documents that are created, or 71 pages of documentation that are created in this process. But you need this documentation to create the full armour that provides the moat around your castle. In this case, at the moment, it's just the family home. So we've created the Family Protection Trust deed there. It's called the Smith Family Protection Trust, and that's all the categories. I won't go through them all, but this is your typical trust deed. The only difference between this trust deed and any other trust deed is we've got this leading member concept, and we've got the ability to remove that person if their assets are threatened, and secondly, appoint another leading member, a substitute leading member in the process. So the deed is, as I said, prepared by Abbott and Morley, which is our solicitors, and it's a deed between the settlor, being Jack being the son of the client, who settles the trust and creates the trust, puts in $100, and the trust is created under law. In order to create a trust, you need an asset to settle it, and that's why we have $100 settlement right up front with most trusts. Obviously, the trustee in this case is the Smith Family Protection Proprietary Limited, which I said we've set up a little bit earlier, which is also a leading member company, which has the director being John Smith, and then if something happens to him or we need to pull him out, we can do so and put in a replacement director in there as well. And also the other party is the leading member and family protector appointor, and the appointor is someone who can remove the trustee. In other words, if we have the Smith Family Protection Company as the trustee, and for some reason John wants to remove that particular trustee, he has the power to remove that trustee and appoint somebody else. He might appoint another family member, or perhaps another company if he wishes. And there, and obviously the rest of the deed has all the typical clauses of any trust deed in there. I won't bore you with that. That goes on for about 30 or 40 pages. Once we've accepted the deed and we're happy with it, we sign it, we witness it, and the deed becomes effective ASAP. The document in relation to creating the financial certificate of solvency, there it is there. Basically, an accountant like myself can provide that certificate, and that needs to also to be signed off, and away it goes. The next major document in relation to the ARMA in this particular situation for the home is that we're going to provide a deed of gift between John James Smith and Mary Jane Smith, because obviously they own the house in joint names, being the gifter, and then the Smith Family Protection Proprietary as trustee for the Family Protection Trust being the giftee. So this document just explains what we're gifting, and who we're gifting it to, and who the giftor is at the end of the day. So again, the deed of gift, a very important document in the ARMA, and is produced as part of that. The Schedule 1, which is basically the gift, in this case it's the net equity in number 1 Power Street, Malvern East, Victoria 3148. And that is the physical property that is gifted, or the net equity that is gifted across. Now, this is the deed of promissory note. The deed of promissory note, again, is between John James Smith and Mary Jane Smith, being the promisor, who promised to pay the loan back to the Smith Family Protection structure. This is the promissory note is obviously, as I said, is a mechanism where we don't have to involve physical cash. It's an agreement that has to be, I guess, followed, once it's executed at the end of the day. So what we're saying is, on the 15th of December 2020, the promisor, John James and Mary Jane Smith, and the trustee, the trustee of the Protector Trust, enter into an arrangement where the individuals promise to pay back the trust a certain amount of money in the future, with with a little bit of interest, just to make it legal at the end of the day. In this particular case, I think I've put in about $10,000 after 30 years, has to be paid back on top of the original loan, which I think is from a legal point of view, it makes the document has consideration, and therefore makes it even more legal at the end of the day. And the physical amount can be paid back at the end of the 30 years or renegotiated again, or if the property is sold, then that settles the transaction as well, and moves any net physical real cash into the protected trust automatically. Obviously, other terms and conditions in the promissory note, signing it, witnessing it, and then dating it makes it official. And obviously, because we've got a promissory note with, so it's basically a loan, we've got to have a loan agreement, again, between the protected trust being the lender and the couple, John and Mary here. And what we're saying in this particular document is we are taking out a loan, and the loan agreement is for the full amount of the equity, which is $1 million, and the interest rate that we've put in is nominated in the schedule, and the repayment, and it's basically an interest-only loan, and also the repayment is going to be at the end of the term of this particular agreement. So there's no physical payments that need to be made on an annual basis in this particular case. So the loan agreement is, I guess, a typical agreement that any lender enters into with the borrowers. As you can see there, it's a fairly comprehensive document that stands up in a court of law. And there has been a case where these documents have been tested, and for example, the deed of gift was effective, and also the loan back was also effective. So therefore, the person who was attacking this particular person basically lost, and the assets for that particular individual were held and protected as a result of these documents. There's a schedule, $1 million. 30 years, however, can be repayable earlier with no penalties. Interest is, as I said, 0.01%, and it can be reviewed every year if you want to. It's interest only, with the repayment payable at the termination of the agreement, and the commencement date, and then the actual property that we're going to register a registered mortgage over. And you can see there we've got the folio number and everything in there as well. That's just an example, that one. However, the mortgage deed is typical, what the same sort of document that the banks prepare. Now, before we take out what we call a second mortgage over the property to protect it, the loan from any other attack, the second mortgage obviously needs to be approved by your first mortgagee. So if you've got a first mortgage, so if you've got a first mortgage, your bank, let's say NAB, will need to physically be told that there's going to be another second mortgage. However, there's enough equity for them to have their first mortgage protected as well. So if something happens, they're going to get their money, but we're going to, most first mortgage agreements tend to have a clause that says, you must notify us if there's any changes to the mortgage. And in this case, there is, and normally we would have a standard letter that goes out to the bank, a conversation that happens with the bank to make sure that they're comfortable with the transaction and they understand it. So the mortgage deed is created. Again, here is the legal mortgage deed that is prepared by Abbott Morley with all the relevant parties and details of the mortgage. And again, that's signed and witnessed, and jobs done. As you can see, there's a pretty comprehensive list of documentation, but again, the solicitors, in this case Abbott and Morley, have done this so many times, and have got it down pat at the end of the day. So very, very comprehensive documentation there. So I just want to go back to there we go, the PowerPoint presentation, and maybe just start to conclude the presentation. So we've done the case study. Hopefully people got some ideas out of that on how what's involved in the protection of your assets using the Protector Trust. So what's the 5 steps to, I guess, to get involved in the process of determining whether you should be putting something like this together in your structures? Well, first thing what we do is we have initial discussion just to see what assets you think need protecting, or even before that is we start to discuss, is there a risk? Do you have a business that potentially is open to future litigation? If so, how do we protect your assets that have been accumulated over the years? And then the second thing we do is we decide which assets we want to protect and the timing of those assets. As I said, you don't have to do it all at once. If you wanted to just to protect an investment property, for argument's sake, or one of your loans that you've provided the company for over the years, you want to protect that part of the assets, or if you want to protect the net equity of the business, in other words, the retained earnings, you can do that, or the assets that are that help run the business, like the plant and equipment, you can do that. You can nominate whether you do one asset, whether you do all the assets. Obviously, the more assets initially, there's more documentation, but I think most people just want to protect the big stuff. So maybe a plan of attack is that you start to bring into the asset protection trust a certain amount of assets every year or every couple of months or something over a period of time. So it's not daunting on you at that you've got all these documents that need to be executed, so to make the moat and the protector very efficient. Obviously, we then have an interview where we gather the information for the documentation, and then it's sent off to Abbott and Morley through their system to create the documentation. And then basically at the end of all of that, we go through and review the structure on a regular basis. Now, you might say, why do you do that, Phil? Well, you do that because, let's say, for example, we've moved a property across in there, and it's, the net equity is $1 million in 2 or 3 years' time. That net equity may be a further 200,000. So therefore, you've got another 200,000 that you want to protect. So that's a very important part of the process. And so basically, as your assets grow, we can keep protecting the net equity in those assets going forward. Also, for example, ongoing reviews may lead to a situation which, there was a question that was raised that, what happens if you want to go back to the bank and borrow another $500,000 to do another transaction of some sort, but you want to use the equity in that particular asset to do that. So yeah, so what you would do then is you would have a discussion with myself, and we would then bring in the strategy to I guess forgive that $500,000 that's in that original mortgage of $1 million, create more equity for the bank, say another $500,000, so you can go to the bank and the bank can take out a first mortgage on that additional $500,000. So I guess if you don't have any future need for any more loans, then you don't have to do that on a regular basis. But if you do, there's a mechanism around, the legal mechanism around how we do that as well. So they're the 5 steps to putting together the Protector Trust. I guess if you've got any questions and you want to discuss it, don't hesitate to give me a call, and we can certainly thrash it out with you and determine which particular documents are required and what structures, if you've got any structures, we can use. If not, what structures need to be created to make this process work for you. Again, thank you very much for attending, and I hope that you've got a lot out of this. And as I said, if you do need to have a discussion, just send me an email and we'll book a time. We'll have initial discussion, and then we'll discuss, we'll sort of formulate a plan on how we implement the protector potentially in your life. Again, this is Philip signing off, and I'll talk to you really soon. Cheers.